Section 4, Chapter 3 of the Third Geneva Convention. Article 82, Prisoner of War. Oh, this is penal and disciplinary sanctions. Article 82, a prisoner of war shall be subject to the laws and regulations and orders enforced in the armed forces of the detaining power. The detaining power shall be justified in taking judicial or disciplinary measures in respect of any offense committed by a prisoner of war against such laws, regulations, or orders. However, no proceedings or punishments contrary to the provisions of this chapter shall be allowed. If any law, regulation, or order of the detaining power shall declare acts committed by a prisoner of war be punishable, whereas the same acts would not be punishable if committed by a member of the forces of the detaining power, such acts shall entail disciplinary punishments only. Article 83. In deciding whether proceedings in respect of an offense alleged to have been committed by a prisoner of war shall be judicial or disciplinary, the detaining power shall ensure that competent authorities exercise the greatest leniency and adopt wherever possible disciplinary rather than judicial measures. 84. Article 84. A prisoner of war shall be tried only by a military court unless the existing laws of the detaining power expressly permit civilian courts to try a member of the armed forces of the detaining power in respect of their particular offense alleged to have been committed by the prisoner of war. In no circumstances whatever shall a prisoner of war be tried by a court of any kind which does not offer the essential guarantees of independence and impartiality as generally recognized, and in particular the procedure of which does not afford the accused the rights and means of defense provided for in Article 105. Article 85. Prisoners of war prosecuted under the laws of the detaining power for acts committed prior to capture shall retain, if convicted, the benefits of the present convention. Article 86. No prisoner of war may be punished more than once for the same act or on the same charge. Article 87. Prisoners of war may not be sentenced by the military authorities and courts of the detaining power to any penalties except those provided for in respect of members of the armed forces of the said power who have committed the same acts. When fixing the penalty, the courts or authorities of the detaining power shall take into consideration the widest extent possible the fact that the accused, not being a national of the detaining power, is not bound to it by any duty of allegiance, and that he is in its power as the result of circumstances independent of his own will. The said court or authorities shall be at liberty to reduce the penalty provided for the violation of which the prisoner of war is accused, and shall therefore not be bound to apply the minimum penalty prescribed. Collective punishment for individual acts, corporal punishment, imprisonment in premises without daylight, and in general any form of torture or cruelty are forbidden. No prisoner of war may be deprived of his rank by the detaining power or prevented from wearing his badges. Article 88. Officers, non-commissioned officers, and men who are prisoners of war undergoing a disciplinary or judicial punishment shall not be subject to more severe treatment than applied in respect of the same punishment to members of the armed forces of the detaining power of equivalent rank. A woman prisoner of war shall not be awarded or sentenced to a punishment more severe or treated whilst undergoing punishment more severely than a woman member of the armed forces of the detaining power dealt with for similar offense. In no case may a woman prisoner of war be awarded or sentenced to a punishment more severe or treated whilst undergoing punishment more severely than a male member of the armed forces of the detaining power dealt with for similar offense. Prisoners of war who have served disciplinary or judicial sentences may not be treated differently from other prisoners of war. Article 89. 2. Disciplinary sanctions. The disciplinary punishments applicable to prisoners of war are the following: a fine, which shall not exceed 50% of the advances of pay and working pay which the prisoner of war would otherwise receive under the provisions of Articles 60 and 62 during a period of not more than 30 days. Discontinuance of privileges granted over and above the treatment provided for by the present convention. Fatigue duties not exceeding 2 hours daily. Confinement. The punishment referred to under 3 shall not be applied to officers. In no case shall disciplinary punishments be inhuman, brutal, dangerous to the health of the prisoners of war. Article 90. The duration of any single punishment shall in no case exceed 30 days. Any period of confinement awaiting the hearing of disciplinary offense or the award of disciplinary punishment shall be deduced from an award pronounced against the prisoner of war. The maximum of 30 days provided above may not be exceeded even if the prisoner of war is answerable for several acts at the same time when he is awarded punishment, whether such acts are related or not. The period between the pronouncing of an award of disciplinary punishment and its execution shall not exceed 1 month. Shall not exceed 1 month. When a prisoner of war is awarded for further disciplinary punishment, a period of at least 3 days shall elapse between the execution of any two of the punishments, if the duration of one of these is 10 days or more. Article 91. Escape of a prisoner of war shall be deemed to have succeeded when 1. He has joined the armed forces of the power on which he depends or those of an allied power. 2. He has left the territory under the control of the detaining power or of an ally of the said power. 3. He has joined a ship flying the flag of the power on which he depends or an allied or of an allied power in the territorial waters of the detaining power, the said ship not being under the control of the last named power. Prisoners of war who have made good their escape in the sense of this article and who are recaptured shall not be liable to any punishment in respect of their previous escape. 92. Prisoner of war who attempts escape and is recaptured before having made good his escape, in the sense of Article 91, shall be liable only to disciplinary punishment in the respect of this act, even if it's a repeated offense. A prisoner of war who is recaptured shall be handed over without delay to the competent military authority. Article 88, fourth paragraph notwithstanding, prisoners of war punishment as a result of an unsuccessful escape may be subject to special surveillance. Such surveillance must not affect the state of their health and must be undergone in a prisoner of war camp and must not entail the supervision of any of the safeguards granted to them. And must not entail the correction, of any of the safeguards granted to them by the present convention. Article 93. Escape or attempt to escape escape or attempt to escape, even if its repeated offense, shall not be deemed an aggravating circumstance if the prisoner of war is subject to trial by judicial proceedings in respect to an offense committed during his escape or attempt to escape. In conformity with the principle stated in Article 83, offenses committed by prisoners of war with the sole intention of facilitating their escape, and which do not entail any violence against the life or limb, such offenses against public property, theft without intention or self enrichment, the drawing up or use of false papers, the wearing of civilian clothing, shall occasion disciplinary punishment only. Prisoners of war who aid or abet an escape or an attempt to escape shall be liable on this count to disciplinary punishment only. Article 94. If an escaped prisoner of war if an escaped prisoner of war is recaptured, the power on which he depends shall be notified thereof in the manner defined in Article 122, provided the notification of his escape has been made. Article 95. A prisoner of war accused of an offense against discipline shall not be kept in confinement pending the hearing, unless a member of the armed forces of the detaining power would be so kept if he were accused of a similar offense, or if it is essential in the interests of the camp order and discipline. Any period spent by a prisoner of war in confinement awaiting the disposal of an offense against discipline shall be reduced to an absolute minimum and shall not exceed 14 days. The provisions of Article 97 and Article 98 of this chapter shall apply to prisoners of war who are in confinement awaiting the disposal of offenses against discipline. Article 96. Acts which constitute offenses against discipline shall be investigated immediately, without prejudice to the competence of courts and superior military authority. Disciplinary punishments may be ordered only by an officer having disciplinary powers in his capacity as camp commander, or by a reasonable officer who replaces him or to whom he has delegated his disciplinary powers. In no case may such powers be delegated to a prisoner of war or be exercised by a prisoner of war. Before any disciplinary award is pronounced, the accused shall be given precise information regarding the offense of which he is accused and given the opportunity of explaining his conduct and of defending himself. He shall be permitted, in particular, to call witness and to have recourse, if necessary, to the service of a qualified interpreter. The decision shall be announced to the accused prisoner of war and the prisoner's representative. The record of disciplinary punishment shall be maintained by the camp commander and shall be open to inspection by representatives of the protecting power. Article 97. Prisoners of war shall not in any case be transferred to penitentiary establishments, prisons, penitentiaries, convict prisons, etc., to undergo disciplinary punishment therein. All premises in which disciplinary punishments are undergone shall conform to the sanitary requirements set forth in Article 25. A prisoner of war undergoing punishment shall be enabled to keep himself in a state of cleanliness in conformity with Article 29. So you don't get to throw them in the oubliette. Officers and persons of equivalent status shall not be lodged in the same quarters as non-commissioned officers or men. Women prisoners of war undergoing disciplinary punishment shall be confined in separate quarters from male prisoners of war and shall be under the immediate supervision of women. Article 98. A prisoner of war undergoing confinement as a disciplinary punishment shall continue to enjoy the benefits of the provision of this convention, except insofar as these are necessarily rendered inapplicable by the mere fact that he is confined. In no case may he be deprived of the benefit of the provisions of Articles 78 and 126. A prisoner of war awarded disciplinary punishment may not be deprived of the prerogatives attached to his rank. Prisoners of war awarded disciplinary punishment shall be allowed to exercise and to stay in the open air at least 2 hours daily. They shall be allowed, on their request, to be present at daily medical inspections. They shall receive the attention which their state of health requires, and, if necessary, shall be removed to the camp infirmary or to a hospital. They shall have permission to read and write, likewise to send and receive letters, parcels, and remittances of money, however, may be withheld from them until the completion of the punishment. They shall meanwhile be entrusted to the prisoner's representative, who will hand over the infirmary and perishable goods contained in such parcels. 3. Judicial proceedings. Article 99. No prisoner of war may be tried or sentenced for any act which is not forbidden by the law of the detaining power or by international law in force at the time the said act was committed. No moral or physical coercion may be exerted on a prisoner of war in order to induce him to admit himself guilty of the act of which he is accused. No prisoner of war may be convicted without having had opportunity to present his defense and the assistance of a qualified advocate or counsel. Article 100. Prisoners of war and the protecting power shall be informed as soon as possible of the offenses which are punishable by death sentence under the laws of detaining power. Let me repeat that. Prisoners of war and the protecting powers shall be informed as soon as possible of the offenses which are punishable by the death sentence under the laws of the detaining power. Other offenses shall not thereafter be made punishable by death penalty without the concurrence of the power upon which the prisoners of war depend. The death sentence cannot be pronounced on a prisoner of war unless the attention of the court has, in accordance with Article 87, second paragraph, been particularly called to the fact that since the accused is not a national of the detaining power, he is not bound by any duty of allegiance, and that he is in its power as the result of circumstances independent of his own will. Article 101. The death penalty. If the death penalty is pronounced on a prisoner of war, the sentence shall not be executed before the expiration of a period of at least 6 months from the date when the protecting power receives an indicated address the detailed communication provided for in Article 107. Article 102. A prisoner of war can be validly sentenced only if the sentence has been pronounced by the same courts according to the same procedure as in case members of the armed forces of the detaining power, and if, furthermore, the provisions of the present chapter have been observed. Article 103. Judicial investigations relating to a prisoner of war shall be conducted as rapidly as circumstances permit, and so that his trial shall take place as soon as possible. A prisoner of war shall not be confined while awaiting his trial unless a member of the armed forces of the detaining power would be so confined if he were accused of a similar offense, or if it is essential to do so in the interests of national security. In no circumstances shall this confinement exceed 3 months. Any period spent by a prisoner of war in confinement awaiting trial shall be deduced from any sentence of imprisonment passed upon him and taken into account in fixing any penalty. The provisions of Article 97 and Article 98 of this chapter shall apply to a prisoner of war whilst in confinement waiting a trial. Article 104. In any case in which detaining power has decided to institute judicial proceedings against a prisoner of war, it shall notify the protecting power as soon as possible and at least 3 weeks before the opening of the trial. This period of 3 weeks shall run from the day on which such notification reaches the protecting power at the address previously indicated by the latter to the detaining power. The said notification shall contain the following information: 1. Surname and first name of the prisoner of war, his rank, his army regimental, personal, or serial number, his date of birth, and his profession or trade, if any. 2. Place of internment or confinement. 3. Specification of the charge or charges on which the prisoner of war is to be arraigned, given the legal provisions applicable. 4. Designation of the court which will try the case, likewise the date and place fixed for the opening trial. The same communication shall be made by the detaining power to the prisoner's representative. If no evidence is submitted at the opening of the trial that the notification referred to above was received by the protecting power, the prisoner of war, and by the prisoner's representative concerned at least 3 weeks before the opening of the trial, then the latter cannot take place and must be adjourned. Article 105. Prisoners of war shall be entitled to the assistance by one or more of his prisoner comrades, to defense by a qualified advocate or counsel of his own choice, to the calling of witnesses, and if he deems necessary, to the services of a competent interpreter. He shall be advised of these rights by the detaining power in due time before the trial. Failing a choice by the prisoner of war, the protecting power shall find him an advocate or counsel, and shall have at least 1 week at its disposal for the purpose. The detaining power shall deliver to the said power on request a list of persons qualified to present the defense. Failing a choice of an advocate or counsel by the prisoner of war, the detaining power shall appoint a competent advocate or counsel to conduct the defense. The advocate or counsel conducting the defense on behalf of the prisoner of war shall have at his disposal a period of 2 weeks at least before the opening of the trial, as well as the necessary facilities prepare the defense of the accused. He may, in particular, freely visit the accused and interview him in private. He may also confer any witness for the defense, including prisoners of war. He shall have the benefit of these facilities until the term or appeal of petition has expired. Peculiars of the charge or charges on which the prisoner of war is to be arraigned, as well as the documents which are generally communicated to the accuser by virtue of the laws enforced in the armed forces of the detaining power, shall be communicated to the accused prisoner of war in a language which he understands, and in good time before the opening of the trial. The same communication in the same circumstances shall be made to the advocate or counsel conducting the defense on behalf of the prisoner of war. The representatives of the protecting power shall be entitled to attend the trial of the case unless exceptionally this is held in camera, the interests of the state's security. In such case, the detaining power shall advise the protecting power accordingly. Article 106. Every prisoner of war shall have, in the same manner as the members of the armed forces, the detaining power, the right to appeal or petition from any sentence pronounced upon him with a view to the quashing or reversing of the sentence or the reopening of the trial. He shall be fully informed of his right to appeal or petition and of the time limit within which he may do so. Article 107. Any judgment and sentence pronounced upon a prisoner of war shall be immediately reported to the protecting power in the form of a summary communication, which shall also indicate whether he has the right of appeal with a view to the quashing of the sentence or the reopening of the trial. This communication shall likewise be sent to the prisoner's representative concerned. It shall also be sent to the accused prisoner of war in a language he understands. The sentence was not pronounced if the sentence was not pronounced in his presence. The detaining power shall also immediately communicate to the protecting power the decision of the prisoner of war to use or waive his rights of appeal. Furthermore, if a prisoner of war is finally convicted, or if a sentence pronounced on a prisoner of war in the first instance is death sentence, the detaining power shall as soon as possible address to the protecting power a detailed communication containing 1. The precise wording of the final sentence, 2. A summarized report of any preliminary investigation and of the trial, emphasizing in particular the elements of the prosecution and defense. 3. Notification where applicable of establishment where the sentence was served. The communications provided for in the foregoing subparagraphs shall be sent to the protecting power at the address previously made known by the detaining power. 108. Sentence pronounced on prisoners of war after a conviction has become duly enforceable shall be served in the same establishments under the same conditions as in the case of the members of the armed forces of the detaining power. These conditions shall in all cases conform to the requirements of health and humanity. A woman prisoner of war on whom such a sentence has been pronounced shall be confined in separate quarters and shall be under the supervision of women. In any case, prisoners of war sentenced to a penalty depriving them of their liberty shall retain the benefit of provisions of Article 78 and 126 of the present convention. Furthermore, they shall be entitled to receive and dispatch correspondences, to receive at least one relief parcel monthly, and to take regular exercise in the open air, to have medical care required by their state of health, and the spiritual assistance they may desire. Penalties to which they may be subject shall be in accordance with the provisions of Article 87, third paragraph.